Hello friends, in the series on the income tax cases, today we will discuss an issue that in case the CIT appeal after considering the submission of the assessee asks for a remand report from the assessing officer on the basis of the submission of the assessee, then after that whether the CIT appeal has the option to dismiss the appeal of the assessee on the basis of limitation. This issue has been taken up by ITAT Amritsar in the case of RADHEY Chowdhary versus Deputy Commissioner of Income Tax, and this case has been reported in 119 ITR Tribunal at page number 543. The date of the judgment is 14th May 2024. In the present case, the appeal of the assessee was delayed by 121 days, and the reason given by the assessee for this delay was that there were two counsels of the assessee and there was some confusion between the two counsels, due to which the appeal was filed late by 121 days. After considering the submissions of the assessee, the learned CIT appeal on the basis of the submission of the assessee asked for remand report from the assessing officer, and then after calling for remand report, the learned CIT appeal dismissed the appeal of the assessee on the ground of limitation. And the CIT appeal order was silent about the merits of the case, and even there was no mention of the remand report given by the assessing officer, and the copy of the remand report was not available on the portal also, and even the copy of remand report was not made available to the assessee. The assessee was also pressing the ground that after filing the return under section 148, the jurisdictional notice under section 143 subsection 2 has not been issued to the assessee, so the assessment is bad in law. The assessee was heavily relying on the Supreme Court judgment in the case of Assistant CIT versus Hotel Blue Moon, which is reported in 321 ITR at page number 362. When the tribunal heard the matter, the tribunal was of the opinion that in the present case, when the CIT appeal has asked for remand report after considering the submission of the assessee, then it is a adequate proof that delay in filing appeal by the assessee is already condoned and appeal already taken for hearing. The tribunal also said that CIT appeal has already travelled beyond the issue of limitation if he has asked for remand report after considering the submission of the assessee. The tribunal also said that in the present case, the appeal order of the learned CIT appeal is silent on the contents of the remand report. Remand report is not available on the portal, and the copy of the remand report has not been made available to the assessee. The tribunal also held that it was not judicial on the part of the CIT appeal to have dismissed the appeal on the ground of limitation once he has called for remand report after considering the submissions of the assessee. And moreover, on the technical ground, the tribunal held in favor of the assessee that since written under section 148 has been filed by the assessee and non-issuance of notice under section 143 subsection 2 is completely forceful in questioning the whole assessment of the assessee by relying on the judgment of Supreme Court in the case of Assistant CIT versus Hotel Blue Moon, which is reported in 321 ITR at page number 362. So on both the grounds, the tribunal was with the assessee and the assessment was quashed. At the end of this video, once again I am repeating the name of the case. The name of the case is RADHEY Chowdhary versus Deputy Commissioner of Income Tax, and this case has been reported in 119 ITR at page number 543. The date of the judgment is 14th May 2024 and The matter has been decided by Amritsar ITAT. Thank you, friends.